everybody to a BCS Law special interest group. We've got a very interesting session today. So unless you have all been hiding underneath a rock or isolating without any communication, you probably would have heard about this case, Lloyd versus Google. It's a Supreme Court decision and it has fairly significant ramifications, both for data protection and class actions. And we're very honored and privileged to have a couple of excellent speakers today. I am a bit biased because they are my colleagues at CMS. So we've got Kenny Henderson, who's a litigation partner and one of the leading class action lawyers in the UK. Good evening, Kenny.
Hi, Sam. I'll do the the thing we have to get done of being delayed and taking myself off mute. So I've gone early, hopefully once. But yeah, hey, Sam, and thanks everybody for joining this evening.
Excellent. And we've got Lee Gardner, who's a senior associate who does all the hard work, and Kenny takes all the credit.
Sam, that's very naughty. That's not how it works. Hi, everyone.
So yeah, I think why this is quite a special event is that both Kenny and Leah have very intimate knowledge of this case because fortunately CMS acted for a couple of interveners. So we do have inside knowledge and we can sort of share that experience. And we're not just reading a case law report like many people who haven't been involved in the case. So we have been very closely involved with this from the start. So without further ado, I should also mention that this is being recorded. It will be Chatham House rules. And if you've got any questions, feel free to put them in the chat box. And Panagiotta, who is our events coordinator, will collate them and then sort of relay that back to Kenny and Leah. So without further ado, I will leave it to Kenny. Thank you, Kenny.
Thanks, Sam. Yeah, so as Sam was mentioning, this is a very important decision. We're not being entirely biased just because we were involved, but class actions is becoming a big deal in the UK and the Europe. It's no longer a topic solely associated with exciting John Grisham books, the US, Erin Brockovich and all those things, moving from the realm of fiction to fact in the UK. And we're going to set out some context to that in a moment before we get into this case. And this case, Lloyd and Google, is really about two topics. First of all, in relation to some data protection issues, substantive data protection law. And then secondly, around the development of class actions in a particular class action mechanism. The way we're going to do this, we're going to pass back and forth. I'm going to make some introductory comments. Leah's going to set out a lot of the law stuff, which is necessary, I'm afraid, to understand really what's going on, but we're going to try and only address the points that need to be addressed for the relevant understanding. We're not going to go into unnecessary detail. And then I'm going to round off at the end talking a little bit about the Supreme Court decision and the consequences of the Supreme Court decision. And if we were to sum up the Supreme Court decision in Lloyd and Google, we could do that in two sentences, really. First of all, is the Supreme Court decision is good news for corporate defendants and large corporates and indeed public sector bodies, not just corporates, public sector bodies that have a lot of data and that are at risk of data protection class actions, because it has reduced the scope, has not eliminated, but has reduced the scope and risk of data protection class actions that arose from the Court of Appeal decision in Lloyd and Google. So that is the good news. This is slightly more than two sentences. I've realized it's 2 bullet points. That is the first point. The second point is bad news, and that is that the Supreme Court decision has expanded and relaxed and made more flexible the class action device that was used in this case that we will come on talk about in a moment, and is potentially opening up further exposure in other areas, and that is a theme we're going to lead off with here, which is where is this? What is the context around this? And as I mentioned in my first few words, there's a rise in class actions in Europe and in the UK. So we in CMS, myself, Leah, and a number of others of us had a wonderful fun in 2020 and the start of 2021, putting together a report on class actions all across Europe, because what you often see is from law firms is you get reports on an individual case, such as here, Lloyd and Google, or an individual piece of legislation coming forward, but there hadn't been actually a cohesive report gathering up the data and gathering up the information on the number of class actions being filed all across Europe. And this is not going to be a big old advert for CMS, but we do have quite a lot of offices across Europe, and so we're in a good position to actually gather up that data. So that's what we did. After a few months, we started regretting doing the project. It was a big old project, but it was very worth doing. And so what we did was we asked our colleagues in various offices across Europe to scoop up data on collective proceedings, so any claim involving 5 or more claimants being brought together on a collective basis. And we also gathered information on the type of procedure being used, because there's many procedures all over Europe. And we gathered information on what sector the defendant was in, pharma, tech, consumerist, etc. And also the nature of the claim. Was it a data protection claim, a consumer claim? Was it an antitrust competition claim, etc. So we gathered up all this information, and some of the key highlights we have are on this slide. So from 2018 to 2020, and this is a snapshot in the 5-year period, this big graphic here. We saw the incidence, the number of class actions being filed across Europe increasing 120%. So that's quite a significant uptick. Class actions against the technology sector increasing dramatically, with 15 times the number of claims filed in 2020 as opposed to 2017. And I'm sure you've already worked out that's a growth rate of 1,400%. Data protection claims, a particular theme of this evening's session, grew by a factor of 11. That's 1,000% between 2016 and 2020. So here's the data. Data is always good to know if you're trying to work out what the reality is. So that's part of the context of this evening's session. There's also been an increase, a very significant increase in the rise of opt-out claims. Now, what do we mean by opt-out claims? Well, Europe has had collective proceedings for many, many decades. Collective proceedings are just a means by which individual claims can be brought and case managed together by the courts. But the tradition in Europe for collective proceedings is for them to be brought on an opt-in basis. And an opt-in basis requires potentially affected persons or companies or consumers, whoever the potential class are, to make an election to positively choose to join the claim. And that could be by way of issuing their own claim and then it being joined together. It could be signing their claim, you could be ticking a box, whatever the step that needs to be taken, whatever the procedural step, it requires a positive act. That's an opt-in mechanism. Opt-out mechanisms, those are the class action devices we associate with the US. Those are devices that automatically coalesce the class. They automatically aggregate the class together. And they're inordinately powerful procedural mechanisms, particularly where the individualized losses are low. Because where the individualized losses are low, there is very little incentive. There is very little feature upside to actually tick the box. And inertia is a very powerful force. If you post out letters to 10,000 people saying, tick this box and post it back to us and you'll get £10, you'll get a number back, you'll get quite a lot back, but you're not going to get anywhere near 100%, even though it literally is free money. With an opt-out mechanism, the full money is gone, it all goes. So that move from opt-in to opt-out a procedure is incredibly powerful, as I say, and that is one of the main features of Lloyd and Google. That's why we're talking about Lloyd and Google, because fascinating and important that the data protection substantive law is, it's the combination of that point with the availability of an opt-out mechanism that really, that's why it was in the BBC News. That's why this is a big and important case and development. And here, this slide is just briefly pointing out that there is a significant rise in opt-out claims in Europe. 2 countries where we see that in particular are the UK and the Netherlands. They're not the only countries where we've got opt-out devices. They're becoming more popular in Portugal. But that's, again, it's another thematic context point we wish to address before getting into Lloyd and Google. The next point we wanted to mention, just by way of context, is, and without getting into too much detail, is just mentioning a little bit about some of the kind of collective redress procedures that are available in the UK, and that's what this slide is about. As you can see, the Lloyd and Google was brought using the representative action procedure, which I will deal with last on this slide. I'll start with the one on the right, collective proceedings orders, CPOs. That's a feature. That's a mechanism that was brought in by Parliament in 2015. The government changed the law and decided, after a consultation, after much debate, that they would actually legislate for and bring in, it was part of the Consumer Rights Act in 2015, a specific group proceedings mechanism, but only for competition claims. So that could be cartel damages claims, price fixing claims, or claims where there's an alleged abuse of a dominant position. So that's only for competition claims. But the radical element in that law and that mechanism is it's got an opt-out mechanism. And for those of you who, I'm sure many of you are class action fans, you will have seen the news, and it is mainstream news, I'm being slightly flippant, of a case called Merrick's and MasterCard. That is a case that was filed a few years ago, went to the Supreme Court, and the Supreme Court handed down judgment December last year in that case, and was quite high profile. It lowered the certification standard for that mechanism, and that's a claim that's seeking £10 billion. It's on behalf of a class of 44 million people against MasterCard to do with the swipe fees that are charged when you use a credit or debit card that are initially charged to the retailer. So that's a hugely significant development that the government decided to introduce that mechanism. The mechanism on the left-hand side has been around in the UK for a bit longer, around about 20 years, just over 20 years. They're called group litigation orders. Those are opt-in mechanisms, so not as radical. And that, again, as I mentioned earlier on, requires people to choose to join a claim. And then they're case managed together. And common issues that are GLO issues, as they're described, are binding on everybody that joined that group. But we see in the likes of data protection, data breach claims, incidents, where they're brought using a group litigation order mechanism, the percentage take-up will be typically in the single figure percentage. The percentage, the number of people who actually join the class on an opt-in mechanism is quite low. And if there is, as I say, the move from opt-in to opt-out is a very radical move, but if there is one silver lining, it's that you don't get adverts anymore. I mean, you've probably seen, you'll have seen the PPI adverts, you'll have seen, mydieselclaim.com, adverts pertaining to data breaches. Those are only necessary because the claimant law firms and the litigation funders are trying to persuade people to join those claims. With opt-out mechanisms, they don't need to persuade you. You could be dragged into the claim, you may not even be realizing it. So that, as I say, we cannot overemphasize the significance of moving to an opt-out mechanism. That shift that's kind of happening in the UK in particular. And then we've got the representative action mechanism. That's been around in the UK for well over 100 years. It's actually the progeny of the US class action law. It's one of our exports. It's an opt-out class action mechanism. It's available for any type of claim, unlike the CPO regime, which is only available for competition claims. We're going to talk about it in a moment. You probably haven't heard about it very much. Main reason people haven't heard about it very much is that historically it has not been considered a viable means for collective redress. It has been kept in the box by the courts. That certainly changed with the Court of Appeal decision on Lloyd and Google, so that's a bit of a spoiler alert, and we're going to talk again in a moment later on about how it could be becoming potentially more available for other types of claims beyond data protection as a result of the Supreme Court decision. So watch, this is the news, this is what's going on here, and the developments that are happening because of Lloyd and Google. So hopefully that was some helpful context. I'm now going to pass over to Leah, who's going to go through some of the substantive law and the facts and give you some of the introductory information on Lloyd and Google.
Thanks, Kenny. Thanks everyone for joining. So the other major part of the context for Lloyd and Google is the rise of data protection claims. And we think it's really helpful to understand the underlying rights and the underlying law that is the subject of the decision to kind of understand why it's newsworthy other than for class action reasons. So in terms of legislation, there's been a long history of data protection law in the UK and the EU. There's been data protection legislation since the 1970s. But the current form of what everyone sort of refers to as the GDPR, or the Data Protection Act 2018, is the UK's GDPR, was introduced in 1984. So it's been around for a fair amount of time in a kind of similar regime, in that it imposes certain duties and standards on those who control data, particular personal data, and it gives data subjects, those who own the data, certain rights. So the Data Protection Act 1998, which was the predecessor to the 2018 Act, was the one that Lloyd sued Google pursuant to. So the 1998 Act is sort of what we're going to focus on, but as Kenny will no doubt come to later, it is highly likely that the decision in Lloyd and Google will have ramifications for the GDPR and the 2018 Act as well, because the compensation provisions are quite similar. So the 1998 Act was based on the Data Protection Directive, which came into force in 1995. And this really stemmed from some fundamental human rights under European law, mainly Article 8 of the European Convention on Human Rights, which was a respect for private and family life, home and privacy of correspondence. And that came in 1950 after World War II. And this is echoed in the more recent document, the European Charter of Fundamental Rights, which is referred to in the Lloyd and Google decision, particularly by the Court of Appeal, which contains a more specific, it contains the right that I just mentioned, but it also contains a more specific right to data protection in Article 8. And it basically says you have the right to protection of personal data concerning you. Such data must be processed fairly for specific purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down in law. And then it also says everyone has the right to access data which has been collected concerning them, and the right to have it rectified, for example, if it's erroneous. So the development of technology over the years has meant it's become increasingly easy for personal data to be collected, transmitted, stored, manipulated, and shared. Public attitudes towards those fundamental rights of privacy and data protection have also advanced. There's been a growing awareness of fundamental rights and freedoms, and parliaments at EU and UK level have been expanding and fortifying the protections that are afforded to individuals' privacy over the last few decades. So one of the key differences, just while we're sort of on the topic of the legislative background, between the Data Protection Directive, which is the subject of the Lloyd and Google decision, and the GDPR, which currently applies, is actually in the title. So GDPR stands for the General Data Protection Regulation. So it's a regulation as opposed to a directive. And the issue with regulations is that they have what's called direct effect, which means that they apply in member states of the EU without the member state having to do anything to implement them. By contrast, directives require member states to take steps within a certain period of time to implement the directive. And the directives usually give member states quite a bit of leeway into how and which parts of the directive they implement. So that's just one example of how data protection law has been being expanded and fortified and offering greater protections to individuals. So what does data protection do? Just to be a little bit more specific, that it imposes obligations on data controllers. It usually sets out, or does set out, some principles that need to be met and conditions that need to be met before you process an individual's data. And we'll come to some of those that were really relevant in the Lloyd and Google decision in a minute. The Act also establishes the Information Commissioner's Office, or the ICO, and they made submissions as an intervener in Lloyd and Google's case. And just to, I found it really interesting that the ICO in 1984, when it was set up, had 10 employees, and now it has over 500 across the country. And it is really taking an active role in enforcing and upholding data protection rights, including by encouraging private enforcement action. And the final sort of bit of data protection law that I think is really important for understanding the Lloyd and Google decision is that there's been an expansion in the extent to which individuals can enforce data protection law themselves. Each of the 1994 Act here, the 1998 Act and the 2018 Act have expanded the right for individuals to claim compensation for loss that they've suffered as a result of a contravention of data protection law. And that's sort of echoed in the approach the ICO is taking as well. So if we move on to the next slide. So what happened in Lloyd and Google? And bear with me if you have if you know sort of about the background, but I think it's important that we start with everyone understanding the same bits that we then speak about later. So bear with me. So Richard Lloyd, the claimant, is a consumer rights advocate, and the background to his claim, it's not new. The Safari workaround is something that has been in the press, and a settlement was paid by Google in the US as well. So it's not new. So he looked at this and went, right, I'm going to bring a group action, which was what was novel about his claim. So in terms of what is the Safari workaround? So Google developed a cookie known as the double click ad cookie, and it could operate as a third-party cookie. So a cookie that was placed on your device when you visited a website, not by the website you were visiting, but by a third party, for example, an advertiser whose content appeared on that website. The double ad click cookie was placed there as soon as you visited that website that had the relevant double click ad content. And without you knowing and without your consent, when you were using the Safari browser between particular dates in 2011 and 2012. What the cookie enabled Google to do was to basically collect what they refer to in the judgment as browser generated information or browser generated data. Things like the date and time of your visit to a given website, how long you spent there, which pages you visited, how long you spent on each page, what ads you viewed. Also, if an IP address could be collected from your browser, that would allow Google to collect your approximate geographical location. And Google then used this data, allegedly, to identify patterns so they could create groups. So the examples that the judge gives are football lovers and current affairs enthusiasts. So they used those labels to then sell advertising services so that subscribing advertisers could target their ads to particular demographics. So that was the double click ad cookie and the information it was collecting. The issue was with Safari, the Apple iPhone default browser between 2011 and 2012 for several months contained privacy settings that blocked all third-party cookies, but it had some exceptions. And the Safari workaround was Google's way of exploiting those exceptions to get the cookie onto users' devices. So Lloyd claimed that this was a breach of the 1998 Act. And basically he said, I said there were some principles that apply, so and conditions that needed to be met. So here are the ones that he focused on. So he said the Safari workaround involved data not being processed fairly, and these conditions weren't met. So condition 1 was the data subject gave their consent. Condition 2, the processing was necessary for the performance of a contract with the data subject. Number 3, it was necessary for compliance with a legal obligation on the data controller or to protect the vital interests of the data subject. And D, it was necessary for the administration of justice or the exercise of various other functions of a public nature. And Lloyd said none of those conditions were met, and therefore the data wasn't processed fairly, and it was a breach of the Data Protection Act 1998. And this gave rise to what you can see now on the slide, thanks Kenny, is a claim under Section 13 for damage caused by that contravention. And the headline making factor was really that Lloyd sought to sue. If you just change the next slide. Great. Lloyd sought to sue on behalf of all affected iPhone users who were resident in England and Wales at the time, and that was estimated to be over 4 million people. And he claimed in his letter of claim to Google that each member would be entitled to about £750 in damages each. And so that, when you multiply it out, led to an estimated £3 billion in damages across the class. And the provision that Lloyd relied on to sue on behalf of class members is that one that's on the slide there. I've extracted it in full. It's Civil Procedure Rules, or CPR, Rule 19.6. And the critical parts are underlined there. You have to show that you as the claimant had the same interest in the claim as class members. And that was the second part of Lloyd and Google that we'll come to. And the first part was about data protection law, and the second part was about this representative action mechanism, which was also the middle one with the arrow on Kenny's earlier slide. Next slide. The claim, importantly, was damages not for financial loss or distress or anxiety caused by Google's alleged breaches, but for loss of control of data. So loss of, the other way of putting it is loss of autonomy over your data, or basically a loss of privacy. So Lloyd wasn't seeking to prove for himself or members of the class that they had suffered financial loss or distress. One thing I will note at this point is that, which is something I forgot to mention on the slide with Section 13, is that although it's not clear on the face of that, thanks Kenny, although it's not clear on the face of that provision, the parties agreed, based on earlier precedents, that there's a de minimis principle that applies. So basically, you can't succeed in claiming damages under that section unless there is a certain threshold of seriousness that's met, and that will become quite significant in the Supreme Court decision that Kenny will explain. Cool. So if we go forward one more. Great. So in order to claim damages that weren't financial loss or distress, Lloyd relied on these two cases, which I've summarized there. The most important of those is actually Vidal Hall, which CMS was also involved in. And it was a claim brought by 3 individuals against Google on the basis of the same facts, in that it involved a claim for damages suffered as a result of Google's breach in the form of the Safari workaround. So 3 individuals there claimed under the 1998 Act, but also at common law for misuse of private information, or MPI. And the Court of Appeal in Vidal Hall had held that misuse of private information is a standalone cause of action, and you can recover for loss of control or loss of autonomy over your personal data when you bring a claim on that basis. So the question for the court in Lloyd and Google was really whether these loss of control damages could also be claimed under the 1998 Act. And if they could, the court then had to decide whether the claim was suitable to go ahead as a representative action under CPR 19.6. And so that involved applying the same interest test and considering what was required by the same interest test. Let's go on to the next slide. So the saga begins. So the High Court, Mr. Justice Warby was the judge who heard the case. He found that Lloyd's claim didn't have reasonable prospects of success, and he refused permission to serve the claim form in the US. So these three decisions of the Court of Appeals, Supreme Court, and the High Court, they are all actually on quite a narrow question of whether Lloyd should be given permission to serve the claim form on Google because Google is a US company in Delaware, and you need permission to serve a claim outside of England and Wales. So that's sort of the technical legal context in which the questions were being asked of the court. But the headline is he didn't have reasonable prospects of success because his arguments on whether loss of control of data damages were available were unsuccessful. So first argument he put was, I've suffered loss because there was an infringement of my data protection rights. And Justice Warby found that that was just a description of the wrong or the tort rather than a description of some loss actually suffered. He also said he'd suffered for the commission, or he suffered loss for the commission of the wrong itself. Again, that was dismissed on the same basis. And finally, he said, as a result of loss of control over my data, which should be available under the 1998 Act under Section 13 because it was available in Vidal Hall and Galati. And he argued that the 1998 Act and the tort of misuse of private information stemmed from the same source. So it stemmed from the same fundamental rights that I referred to earlier in the European Convention on Human Rights and the European Charter of Fundamental Rights. Justice Warby held that those claims were completely different, and loss of control of data damages were not available under Section 13. He said Section 13 required there to be financial loss and or distress. And so he dismissed Lloyd's arguments on that basis. He then went on to consider whether the court should order that the claim continue as a representative action. Here he found that the same interest test wasn't met because the claimants would have inevitably suffered different levels of damages. He also identified some issues with the class definition. So he said, it would be impossible to sift out of the class iPhone users who change their browser settings at the outset from the default Safari ones. And how would the court actually go about working out how would claimants themselves go about working out whether in a 6-month window 6 years ago they actually had this Google Click ad cookie installed on their system? How would you verify that? So he said there were difficulties with the class definition, and that bore heavily on his discretion to it would bear heavily on the court's discretion as to whether to order that the claim proceed on the representative action basis. And finally, the High Court decision was interesting because Mr. Justice Warby seemed to have really little patience for the claim. Google had made a submission which described Lloyd's claim as a contrived and illegitimate attempt to shoehorn a novel opt-out class action into the representative action procedure in circumstances where Parliament has not considered it appropriate to make such a claim available. And it seems like Justice Warby had some sympathy for that. And he says in his judgment, it would not be unfair to describe this as officious litigation embarked upon on behalf of individuals who have not authorized it and have shown no interest in seeking any remedy for or even complaining about the alleged breaches. So he really was expressing some intolerance for the whole idea that this type of claim might be brought as a representative action. So moving on to the Court of Appeals decision. Let me just check how I'm going for time. Cool. Moving on to the Court of Appeals decision, the Court of Appeal took a completely different view from Justice Warby. It held that in terms of data protection damages, loss of control of data damages were available under the 1998 Act. And that was precisely because, as Lloyd argued, the tort of misuse of private information and claims under the 1998 Act were founded on the same underlying regime of protection of privacy at the EU level. And the Court of Appeal was really influenced by the precedent in Gulati and also the principles of equivalence and effectiveness. And those are principles of EU law that basically say where you've got procedural rules governing actions that safeguard individual rights under EU law, you can't then have domestic law, or you shouldn't interpret domestic law in a way that gives a lesser protection. So in other words, the protection should be equivalent. And the principle of effectiveness, which is basically that a member state shouldn't render it practically impossible or really difficult to exercise rights that have been conferred on individuals by EU law. And so on that basis, the court found, well, on many bases, all influencing, pointing towards the same conclusion, they found that MPI and the 1998 Act were similar domestic claims, and they should be treated in the same way. So, you know, would it be correct, the Court of Appeal asked, to find that loss of control over telephone data in Gulati, which was a phone hacking case, could be compensated, whereas loss of control over the browser generated information couldn't be compensated? And they saw a bit of an inconsistency in that, and that was quite influential in their decision to allow the loss of control of damages. In terms of representative actions, the Court of Appeal was also accepting of Lloyd's arguments, and their conclusion very much flowed from the conclusion that you could claim loss of control of data damages. They basically said, you know, if each class member has suffered this common impact of all having lost the right to control your personal data, then they've suffered the same damage, and they therefore have a common interest in the claim. And having decided that, it was quite a simple, straightforward process to get to the conclusion that they have the same interest and the matter could proceed as a representative action. They also didn't struggle in the same way with the class definition. So in terms of implications, I mean, as sort of evident from the headlines on that slide, commentators really thought the Court of Appeal's decision was going to open the floodgates to data protection class actions, and it kind of did. And there are still data protection class actions in the pipeline that are yet to be decided, you know, after the Supreme Court's case, after the Supreme Court's decision, and it's yet to be seen whether they will go ahead or not. So I'll hand over to Kenny to describe the next part of the Lloyd and Google case.
Thanks, Leah. Yeah, I'd just like to emphasize, you know, the excitement that the claimant law firm body group and also litigation funders felt following the Court of Appeal decision. Hey, we can bring opt-out collective redress mechanisms without the need to persuade people, class members, to join. It can be available for any breach of, well, it was formerly on the 1998 Data Protection Act, but any breach that is not de minimis. The Court of Appeal judgment did say it wasn't available for accidental one-off data breaches, but perhaps subtext for data breaches that are not accidental and one-off. But also a number of the claims that were brought off the back of the Court of Appeal decision were not data breach claims, they were data misuse claims, where there was question marks over the degree of consent that data subjects had given to the processing of their data, where there was use of ad tech and third-party cookies, etc. So there was a range of claims filed, against Salesforce, Oracle, TikTok, YouTube, Google, eye-wateringly large numbers of members in the class, many millions in many of these claims, all off the back of the Supreme Court, the Court of Appeal decision. And not only do the claimant law firms not need to sign people up to the claims, but they don't need to prove damages, because the claim is, as Leah was saying, the two central points here are, first of all, is it possible to get damages for loss of control of data? The established law and data protection claims that you can get damages if there's material damage. That's usually pecuniary harm, financial harm, if your credit card data is taken, for example, and also for distress. So those are the two heads of damages that we've had for a long time. So the first really important point is whether it was possible to get damages for loss of control of data. That was new law for a data protection claim that Lloyd was trying to establish. And second and that's a question of substantive law. And second is a question of procedural law. Can claims of this nature be brought using the representative action mechanism, which, as I mentioned earlier on, and I'll go into a little bit more detail in a moment, has been around for a long time, but has historically not really been available. And so, as Leah said, the decision by the Court of Appeal to allow this claim to proceed using the representative action mechanism really followed directly from their decision that damages were available for loss of control. The Court of Appeal didn't broaden that narrow door, that narrow same interest doorway that is required to walk through for representative action claims. They just said that for this claim that fitted through that door, like these sorts of claims do fit through that narrow door. And so hence we saw all these other very large claims, enormous claims being filed. So those are the two critical points to be bearing in mind as we move into the Supreme Court decision. Incidentally, the Court of Appeal decision was unanimous and was in favor of Lloyd. The Supreme Court decision was also unanimous, but against Mr. Lloyd. So, there we have it, unanimity, but going in the opposite direction. So on the first point, are damages available under the 1998 Data Protection Act for loss of control? Very simply, the answer is no. Supreme Court didn't have much difficulty in answering that question. They said that was on the basis of the clear reading of the statute. In fairness, Section 13 does say nothing about claiming damages for loss of control. So that was it. On that basis, Lloyd's claim fails. But the Supreme Court went on to tell us a lot more. They told us a little bit more about substantive data protection law, and then a lot more about the representative action mechanism, which is what I think is the really interesting part. So I'll probably spend a bit more time talking about that. Leah mentioned the fact that where the Court of Appeal looked at the arguments by Lloyd for the availability of loss of control damages, they looked at the Galati case. The Galati case was a case brought for misuse of private information, which is an English domestic law tort. But they both emanate, that English domestic law tort and data protection law, they both emanate from the Charter of Fundamental Rights. And so the Court of Appeal said, well, actually, if you can get loss of control damages for one, then on principles of equivalence and effectiveness, these EU law principles, then surely we must be able to get damages for loss of control and data protection claims as well. So that's what the Court of Appeal said. Supreme Court unanimously disagreed, saying no. Misuse of personal information is a English domestic law tort, which it is, and how that is interpreted has no bearing on availability of damages under a statute which is there to which is emanating from an EU directive. So that's it. That's the substantive law stuff on data protection law from the Supreme Court. That's it. Google's claim failed on that basis. Supreme Court could have stopped there, but fortunately for all of us, they didn't. Well, in terms of kind of getting you know, a bit more of an understanding of the representative action mechanism. So let's move on to this, and let's drill down into this mechanism. So the representative action mechanism, as we mentioned earlier on, it's been around for a long time. You know, it's been around for well over 100 years in England. And the sole question, the sole requirement is that the class members and the representative must have the same interest. Now, that's a commonality requirement, the degree of commonality. And when I mentioned earlier on the competition, the CPO regime that the UK brought in 2015, that also has a commonality requirement. That the commonality under that regime is that the class members and the representative must have the same, similar, or related interest. Same, similar, or related is broader as a matter of grammar than the same interest. So that's a broader same interest test. Sorry, a broader commonality test than under the representative action mechanism on the face of it. But more dramatic than that, going back to the 1910 case of Market, which was one of the very important cases that looked at the representative action mechanism, it had interpreted the same interest test as essentially to require that there is an identical interest between class members. So that's a really tight commonality test. And that is one of the reasons that the representative action mechanism has historically not really been considered to be an effective means, an effective mechanism for bringing collective redress. Notwithstanding, it could be brought in an opt-out basis, which is very, very powerful. That's of no use if the courts consistently say, consistently reject the efforts to use that mechanism. So, however, and this is where the first point the Supreme Court said, which was very interesting, was given the leading judgment, Lord Leggett said, "I do not think that markets should be understood in this way as requiring identical interests." So there's a big statement saying, you know, the understanding that we've had to date broadly in relation to the same interest test is wrong. Okay, well, the Supreme Court have got the final decision on that. So if that's what they say, then they're right. They then went on to say, well, you know, to go into a bit of a discussion about this same interest test, which is the sole requirement in the procedural rule. There is a further requirement in relation to recovery of damages I will come on to in a moment, and that's very, very important. But just focusing on this same interest test for now. They said, so long as advancing the case of class members affected by the issue would not prejudice the position of others, there is no reason in principle why all should not be represented by the same person. So what are they saying here? They're saying it doesn't matter if there's people in the class who have got interests that are different to other class members, as long as advancing the interest of some class members doesn't prejudice the others. That's an absence of conflict. They don't want there to be a conflict of interest between class members. Now that makes sense, of course, but it's not the same as the same interest. It's pivoting the test from one of commonality to a test that requires absence of conflict. So that is a different approach, but it's the Supreme Court, so you know they're right by definition. And then the final point that they said, which was a development of the second point here on absence of conflicts, they say where there are divergent interests, and then in this context, they mean interests that are different but not conflicting. So that means interests that aren't the same because they're different. They say any procedural objections can be overcome by bringing two or more representative claims and combining them in the same action. So what are they saying here? They're saying let's recategorize the same interest test as to be one that requires absence of conflicts. And anyway, don't worry about it if there are divergent interests that aren't the same. That can be dealt with pragmatically through different representatives and case managing them together. So they're basically saying, don't worry so much about this hitherto understood as a very stringent test. It is not as stringent and as strict as had previously been understood. So that is new. That's a big deal. Then they went on to a topic which is a little bit more challenging. And they said, well, actually, really the hard piece around this is where the representative action mechanism is being used to seek damages on behalf of a class. what has been limiting the scope, what limits the scope of claiming damages in representative proceedings is the compensatory principle on which damages for a civil wrong are awarded. That's to say, if I bring a claim in my own name, our system is predicated on awarding damage to me on a compensatory basis, subject to rules of causation and remoteness. If I prove my claim, then I should be put in a position I would have been absent the breach. That's how our system broadly works. There are some exceptions, but that's how it broadly works in terms of civil litigation. Now that is often very challenging for group litigation, where people have got divergent amounts of harm they've suffered, and also where you need to prove their harm. That's quite challenging. Under the CPO regime, the competition regime, there is a concept of aggregate damages, and that was introduced again by statute, specifically permitted in that regime only. And under that mechanism, the tribunal, the Competition Appeals Tribunal, can award class-wide damages. They don't need to calculate from the bottom up class members of the group damages, but that's not available for representative action mechanisms, representative action claims. That was specifically brought in 2015 for the other regime. Now, Lloyd tried to overcome this difficulty by arguing that loss of control of damages in of itself entitled Lloyd to damages. It was innovative arguing, it was very creative arguing, and the Court of Appeal agreed, so got them pretty far. And they also said that to the extent that class members had varying degrees of browser generated information collected and used by Google contrary to data protection law, Lloyd disavowed any damages above the lowest common denominator. And they were doing that to kind of address this point of there being divergent circumstances and potentially divergent amounts of damages amongst the class. So that again, some creative thinking. Now, the Supreme Court did not address and didn't actually make a ruling on whether that lowest common denominator approach was allowed in law. Lloyd failed for other reasons as well, but that's an interesting open question for other cases. So, as we said, the Lloyd's claim failed on a number of grounds, including the substantive data protection law question of whether you can get losses for loss of control of data. But Supreme Court did go on and signpost some points, in terms of how this mechanism could be used for other class actions. Aside from the relaxation and broadening of the same interest test, they said that the key one of the challenges is the need to prove damages on a compensatory basis. But I think this is the most important sentence in the judgment, the first quotation in this slide, which says there is no reason why damages or other monetary remedies cannot be claimed in a representative action if the entitlement can be calculated on a basis that is common to all members of the class. So this is an endorsement. This is an approval from the Supreme Court. This mechanism can be used to award damages on an opt-out basis for persons who have not chosen to join the claim if you meet this hurdle, if the claimant law firm and the funders can find cases where the entitlement can be calculated on a basis that is it's common to all members of the class. And what does that mean? I'll come on to that in a moment. Next slide, very important point. And the next quotation is the one I alluded to earlier on in the slide. Lowest LCD, lowest common denominator approach. As I said, the Supreme Court decided to not rule positively in favor or against the availability of the lowest common denominator approach. Lloyd's claim failed for other reasons, but they did say, they're prepared to assume that would be permitted for other cases. So we'll see that being used again going forward. So where next? I'm going to deal first with this question of common proof, and then I'll address some of the other points. So what is common proof? And this is the point here, the first quotation, the possibility of calculating damages on a basis that's common to all members of the class. You need to remember that in these sorts of claims with opt-out mechanisms, class members are not active in the class, whereas a group litigation order mechanism and where people have opted into the class, they are active participants in the claim. The court will select certain lead claimants and lead defendants, and they will have to participate. They'll have to adduce direct evidence, witness statements, go through disclosure, provide the evidence. For opt-out mechanisms, such as the representative action mechanism, class members aren't active. Many of them won't even know they're in the claim, that they're potentially going to be bound by a judgment. So how do you address this issue? This was the key question. Well, there's a number of ways. It could be permitted to get evidence from the defendant through disclosure and discovery. Will it be possible using economic methods to calculate damages on a class-wide basis? Can an economist attribute value to certain types of claims and certain types of losses in a means that's satisfactory to the court? These are the sorts of things that the claimant law firms are thinking about now. What is the subset? What does Lloyd and Google leave on the table for these sorts of claims? So that the concept of common proof is, I just want to be absolutely clear on this, the concept of common proof is a means of proving damages without the need for using the active involvement of class members. So that's the exam question, if you like. So where are we on data protection claims? Well, first of all, as Leah mentioned earlier on, Lloyd and Google was a claim brought under the Data Protection Act in 1998. And the Supreme Court explicitly said that their findings did not apply to GDPR. Reserve judgment, there probably will be people who try and bring claims for loss of control damages under GDPR, but they're still going to face the same challenges of proving the losses, even if as a matter of law, damages are available for loss of control. They still need to prove on a compensatory basis, so that will only be a partial answer. So in relation to data protection claims, after the Court of Appeal decision, we really did have this floodgate scenario where it looked like damages may be available to be awarded purely on the basis of loss of control without need to prove losses. We're not in that place now. Lloyd and Google has reversed the floodgates, but there still could be subsets and types of data protection claims that might be possible to be brought using the representative action mechanism. So, for example, where there is a type of people who've been impacted by a particular incident or data protection breach, that that a degree of distress has been suffered by all the class members, provided that the court then allows a lowest common denominator approach. That everybody has suffered some distress, and as long as it's above the de minimis threshold, that's a necessary feature of data protection claims, then it's perfectly possible that those claims could be allowed. Without going into it in too much detail, because we don't want to signpost too much to claimant law firms, my view is that the sorts of uses of data which are kind of transactional in nature, the sorts of uses of online services that are kind of a transactional compact, where certain people are quite comfortable, irrespective of the substantive law, to share data on themselves and aren't that bothered about breaches of data protection law in return for a service that is not being paid for financially. There's a very divergent, there's a human divergence of views there about whether or not there would be distress. Those are not the sorts of claims that are going to be suitable. They'll have to be the sorts of claims where, by its very nature, because of the nature of the breach and because of the nature of the distress, the nature of the breach and the nature of the data, that there will be a minimum threshold of distress being suffered by everybody in the class. Perhaps also by nature of the type of people involved. Maybe it's medical data. Then you could expect a degree of distress to be suffered as well. Misuse of private information is again, it wasn't used in Google, in Lloyd and Google, but for the sorts of claims that fall within those criteria and fall within those Venn diagrams, those elements in the Venn diagram, misuse of personal information claims, private information claims could also potentially be brought as representative actions. Bifurcated proceedings, what's that? So the Supreme Court did say, it's perfectly possible for this mechanism to be used in a bifurcated process where liability is established using the representative action mechanism. And then there's an opt-in process on the damages piece that is of less attraction to the claimant law firms and litigation funders for the reasons I've already identified, which is you get a far lower percentage uptake on opt-in mechanisms and where individual damages are lower. But also the Supreme Court identified a further problem, which is that on the stage of the claim that is on liability only, damages are not awarded. So it's going to be challenging to get a litigation funder to fund a element of the claim where there is no money coming back to them, where following the award, following the ruling on liability, competitors could come in. There could be a variety of claimant law firms all advertising recovery of losses once liability has been established. So I'm not sure we're going to see a great deal of that in the data protection space. Also, final point in this slide is that the government has been consulting the Department of Culture, Media and Sports, ran a consultation late last year and then earlier this year on introducing a specific statutory mechanism under GDPR for an opt-out class action mechanism. The government at the time said, no, we don't see the reason to do this. This was in the back of the Court of Appeal decision in Lloyd and Google. They said, we don't need to do this, in part because Lloyd and Google in the Court of Appeal has demonstrated it's possible using the representative action mechanism. The government has subsequently confirmed, even off the back of the Supreme Court decision, they're not going to change their view. But no doubt, no doubt the government will be being asked to reevaluate that position as well. So there's this statutory public policy question here, whether the government would introduce a mechanism much like it has on competition claims for opt-out class actions. So what about other categories of claims beyond data protection and this very clear relaxation of the same interest test? What is the scope for class action risk there? Well, what we're not going to do, because our clients would be very unhappy with this, is provide a kind of a hit list of the types of claims that could be brought. So I'm afraid this is a bit of a teaser, but the main point here is that class action risk has increased outside of data protection because of this. But questions that would need to be considered are, is individual proof scalable? What would be the sort of claim that could be brought on an individual basis with limited or no input from that individual? And can that be brought on a class-wide basis such that those class members don't need to adduce individual evidence? If the answer to that is yes, then the representative action mechanism may be practical. Related to that point is the common proof or important data pertaining to common proof in the hands of the defendant that are going to be brought through disclosure and therefore not requiring individual evidence. And then, without giving a roadmap, it's fairly uncontroversial that consumer product claims and antitrust claims work particularly well using these mechanisms. That is clear from the US, so that's not giving away too much. Bifurcated proceedings as well, as I mentioned earlier on, they are available. The Supreme Court says that, and that may be suitable where individualized harm is higher and where there is sufficient incentive to opt in. So just to wrap up, just mindful of the time, I did spoil this at the start, spoiler alert at the start, the snapshot, the takeaway, what does Lloyd and Google mean? Well, in relation to the Supreme Court decision, this is, in relation to data protection class action risk, it is good news. It has reduced and has, averted the floodgates that we did potentially see from the Court of Appeal decision. But the bad news is it really has potentially increased, again, not in a floodgates way, but in a way that there will be types of claims that are suitable for the representative action mechanism that had not been available for the Supreme Court decision, because it points out the market had been understood and it's given that signposting for where this mechanism will be available. So that's the takeaways. I know I mentioned them earlier on, but it's worth reiterating them. So thank you very much for your attention. I'm going to pass over back to Sam now, in case there have been any questions from the audience.
Thank you very much, Kenny, and thank you very much, Leah. There were two questions in the chat. One from Joseph de Graft. What happened to punitive damages? Because essentially action was taken that infringed on UK citizens' rights. I don't know if Kenny or Leah would like to take this question.
So I'm happy to have a first go at that. So the UK does not really have a developed regime for punitive damages. We do have what's known as exemplary damages, which is a very similar concept, but they're very, very rarely awarded. There's three possible criteria, like where they're available under statute or where the behavior of the defendant was calculated, kind of cynically in a manner where they knew that their benefit would outweigh anything that have to be in compensatory damages. So you'd have to prove that. You have to prove that that was a calculation on the part of the defendant, and that happens incredibly rarely. But there's a policy point behind this, I think. The fact that there's a policy point behind this, which is, what is the function of civil litigation? If the policymakers decide that they wish to ensure that there is no financial upside where there's been a breach of law, then opt-in mechanisms, aren't necessarily the best avenue, because where individualized damages are low, the participation rates are low as well. So if the policy consideration here is to ensure that a corporate wrongdoer does not benefit, then there is an argument. This is what the claimant law firms would say, and litigation funders would say, is that the opt-in mechanisms are not fit to purpose. But there's a lot of public policy considerations around here. That ignores the role of regulators. Our civil litigation function is mainly about compensatory purposes, to compensate claimants rather than to disgorge money from defendants. That's how our system typically works. And where there's fines leveled by regulators, part of the purpose of here is part of the purpose of this, of regulators, is a deterrent approach. I will make one more point on this, which is that where class action mechanisms are being developed, they need to be done very, very carefully, because regulators have got a kind of a public policy role, and they will pick and choose the cases that they choose to enforce against. Where you've got class action mechanisms, they're frequently driven by financial incentives. They're driven by financial investors to an extent, who are seeing a profit motive. And where there is a lot of settlement pressure on corporate defendants, that is misaligned with the merits of the case, whether or not, because we can assume there's been a wrong. Often there may not have been a wrong, but where you've got a class action mechanism that imposes a lot of settlement pressure that does not examine the merits of the case, that is also not particularly good policy, because you're encouraging claims, not just against corporates, but against the public sector as well. The government is very often, particularly in Australia and in other areas countries where there's a developed class action regime, the government is often a defendant to these claims. And so you've got a transfer of capital from the public sector to the backers of these claims. So I've probably answered the claim in far too much detail, but there's a lot of these are policy points which probably should really be addressed in public debate rather than being developed by judges, in my view.
I don't know if Joseph would wish to take the floor, because there was a follow-up question asking if that is inherent. So I don't know, Joseph, if you want to take the floor, you could unmute yourself.
So what we've done is unmuted everybody. So we've taken off the security control, so you can unmute yourself and ask questions. Can I suggest that everybody sort of raises your hand if you want to ask a question, and then Panagita can sort of ask that particular person who's raised a question to actually ask the question. So Joseph, I guess you're sort of first off the blocks. You had a number of sort of follow-ups. So do you want to ask those now?
Yeah, apologies. So, sorry, you cannot hear me, right?
We can hear you.
Okay, so I mean, yes, I forgot that punitive doesn't exist in British law. Apologies. And I totally understand that there should be a regulatory body that goes in and says, you did something wrong, this is your punishment, whatever that is, right? My confusion is, if Lloyd showed clearly that something wrong occurred, which he did, right? Even if his particular details of his claim did not meet the necessary tests for compensation, whether to Lloyd or to anybody else. For me, what I'm struggling with is they did something wrong, right? They planned, designed, developed, implemented, deployed, and then took everyone's data, whether they made money from it or not, whether they made a profit from it or not, what difference does it make? They did something wrong, right? So at that point, shouldn't somebody be saying, okay, there's two things here. There's the impact on each individual whose rights were infringed upon. Then there's the general thing, which is saying you can't behave that way. Full stop.
Yeah.
I mean, I understand where you're coming from, Joseph. I think it's important to keep in mind that when you bring a claim like Lloyd did, he's really working within the confines of the powers that the court has to award damages under that particular section, which we put on the slide, that's section 13. And so basically how it works is Lloyd says, okay, I've met the criteria for damages, but the court only has power to award the damages that that section provides for. And that section provides for compensatory damages, which are different from punitive damages or exemplary damages or anything that is determined by the wrongfulness of the defendant's conduct. So the court, I mean, even if the court really thought, you know, this is really wrong and it's obvious to the world that it's wrong, the court's hands are tied in what they can award because their power to award is dependent on that narrow section. And so, you know, often the courts say in those circumstances, we sympathize with the claimant. We understand that it's amusing that the law, or it's terrible that the law, you know, allows defendants to behave in this way, but it's a matter for Parliament. And that's kind of what Kenny was getting at, in that it's sort of common view amongst lawyers because of the division between what parliaments and courts do, that in those circumstances where the law just doesn't provide a remedy, the law just doesn't sort of encourage or incentivize and punish and you know and sort of shape behavior in the economy and in society, it's a matter for Parliament to legislate or to pass new laws that allow the courts to make those kind of orders. I mean, there is actually mention of what's called vindicatory damages in the Supreme Court decision, because one of Lloyd's arguments was, I've suffered just because you've done this wrongful act. And the difficulty for the court was that even if they accepted there's been a wrongful act, the wording of that section that gives them the power to award damages doesn't support that, in that it really just says compensation, which means you have to show a loss. And the damages are on a compensation basis, not on a how bad was the wrongdoing basis. So totally get where you're coming from. It's an unsatisfactory answer, because it's basically, the answer is, unless the court's being given that power expressly by Parliament, their hands are tied. Yeah. So the solution is outside of the courts.
I should maybe just add as well, so Lloyd didn't show that Google had done any wrongdoing. The case did not proceed to that basis. It was actually a very early stage in the case. It's in a procedural find. Now, as Leah mentioned, there was regulatory involvement in the US, and the ICO did not take enforcement action against Google in this case. And it's quite unfortunate it's Google, because Google's does I'll be careful what I say. And Google is kind of a target, if we like, in terms of kind of these sorts of comments. But where the judges develop new law, it has got precedential value and doesn't just apply to Google. So, for example, the Court of Appeal ruling would have permitted damages claims to proceed on an opt-out basis for any non-de minimis breach of data protection law. And for those of you may have heard of the Schrems II decision. The Schrems II decision was a regulatory decision that basically found that for many of the data transfers out of the EU and into the US, they breached data protection law. Now, that is a regulatory and practical matter from all intents and purposes. And the ICO will be very careful, and many regulators are kind of cognizant of the need to continue data protection, sort of data transfers, but subject to the law. Now, if you can have a class action mechanism for any sort of breach of data protection law, because we talked here about motives and financial making, but that didn't come into the court's analysis. The question was whether there was a non-de minimis breach of data protection law that sounded in damages. And this is what I mean about the kind of the Google behavior can become a little bit, it can become a motive and can create bad law. But there was a real floodgates risk following the Court of Appeal decision that any sort of those transfers could also lead to class actions as well. And that's questionable policy. And now it's back to Parliament, really. Sorry. So I know there's a hand up and there's been a couple of other questions here. So
yes, before giving the floor to Dr. McGibbon, I will raise the question of Dr. Stephen Castell, one of our members also in the specialist group. So Dr. Castell asks if this case will have any relevance, in your opinion, to class actions in US courts. There was also a couple of follow-up questions from Stephen. I don't know if Stephen wishes to take the floor, but this was the initial question in the chat.
Yes, Stephen, feel free to sort of elaborate on those questions for Kenny and Leah. Yeah.
Thanks, Sam. Can you hear me?
Yes, we can.
Yeah, not a lot of elaboration. There was just a kind of mechanical point, whether and if so, to what extent is Lloyd v. George, like the Supreme Court decision, and maybe the whole history of it, likely to be, or is it amenable to be applied or referenced to any US court actions? I mean, given that when we're looking at data breaches globally, it's likely to involve a US company, more than a non-US company, let us say, in the round. And many actions are ongoing all the time, class actions against US companies in US courts, many of which may be to do with data protection, even though they may not be following GDPR quite as religiously as we are. I just wondered, that was just a mechanical point. Is it likely that a US attorney is going to pay any attention at all to Lloyd v. George? I mean, he probably doesn't have to because it doesn't have force in, but is he likely, do you think, to draw on the sort of arguments? That was the first question. But the other one was, I think, was sort of answered by Leah about the, what was it, this last point we were talking? Yeah, the fact that, I think Joseph said, the fact that somebody's been just naughty and cynical, as I've always understood English civil law, doesn't mean diddly squat. You've got to actually show damages and this compensatory principle. I mean, I was taught by QC 30 years ago, you don't go to civil courts for law, you go for money. And you've got to be able to show that you want compensation to redress some financial harm to you. They're not there to make judgments on being naughty or on being cynical or on being moral or immoral or whatever. And I think that may be a problem with the fundamentals of data protection law, because there's and that's where human rights comes into it. Human rights and data protection seems to speak to moral and subjective judgments about human behavior, not simply being able to prove financial damage, which is a purely sort of capitalist thing, which can be done very objectively. And I just wondered what your comment would be on that. So two completely different points, really. Thank you.
I think it goes to a different purpose. Whether you're talking competition and antitrust law, where the CMA, the Competition and Markets Authority, is the regulator, or data protection where the ICO is the regulator, or financial services where the Financial Conduct Authority is the regulator, there may be circumstances where they look at the effect of the conduct, but they're basically looking at the conduct itself and whether that's breached the relevant regulations and the relevant law, and will they issue a fine. So, and those are very clearly defined legal principles in those areas, and those can be appealed by the courts, but they're not there. They're very rarely there to serve a compensatory effect. And where the CMA or the ICO impose a fine, that fine is not that they don't then go look to the people who are affected and then seek to distribute that money to the people that are affected. That's not the role of the regulator. But we do have a very strong.
Sorry, I would add that to being one of the deficiencies of regulators in this space. Frankly, the citizen couldn't care diddly squat against a company getting a huge fine. he or she wants to know what happens to the money I've lost. Why do I have to go and employ expensive lawyers just to get back a couple of £1,000 that I feel I've lost? I mean, it may just be feel rather than able to prove it. I think that's particularly, don't know about the financial services and competition law. There may be other considerations there, but I feel that is a fundamental issue in data protection. The ICO, in my view, is totally unfit for purpose in terms of what we're trying to achieve with data protection, technically and societally. It is not there to serve the people it says it serves, which is the private data subject. Hasn't got any interest in that. It only can end up giving a fine against the company, usually years after the harm actually occurred, which is another point about, justice delayed is justice denied.
Yeah, I know there's been a hand up for a while, but I'll just make one further point, which is I think people's views about this can often be very much influenced by the particular conduct and the perceived motivations of the data controller or processor. And again, I think Lloyd and Google is, it's on one end of the spectrum of conduct. Now, if you take a company that's the subject of a criminal hack by, sophisticated foreign hackers, that company may have breached data protection law if it does not have sufficient technical and organizational measures in place. And it's therefore, and it is then subject and goes through the same possibility of being subject to group litigation, etc. And so there is this kind of adage about hard cases make bad law. But so much I think of what we've been discussing since the end of the presentation are questions of policy. And you mentioned kind of the motivations of people and desire compensation. There was a study by the US Federal Trade Commission, which looked at the extent to which damages awards and settlement awards are actually distributed to class members in the US in consumer class actions. And the mean distribution was 9%. So that's 9% was the mean figure that was distributed to consumer class mechanisms, the consumer class. So I'm not sure there is a perfect solution to any of these, balancing acts. But I think the government needs to be very careful and think very carefully about the detail when considering class action mechanisms.
I think the floor now goes to Dr. McGibbon. He has raised the question also in the chat. The loss damage can be small for each individual, but large enough in aggregate to change the abuser's behavior. I don't know if Dr. McGibbon will wish to take the floor.
Yes, thank you. So I spent my life in the IT industry and then come to the law of late, working in technology policy before. But I wanted to start by just saying thank you to Kenny and Leah. I thought that was a really, really excellent presentation and an extremely good use of my time. I don't know about anybody else, but I assume the same. So thank you for that. To the previous comments, really, I think I observe that there's sometimes a mistake in commercial organizations when they think about data protection. In my view, data protection really is about the protection of the individual against the state, not so much against individual companies. And that's far more of a privacy concern. And the point of connection is this, that I don't think most people that would join these claims or would be included in an opt-out scheme by default are actually interested in making $1,000. I think $3 is probably more. What they're really interested in is seeing a change in the behavior of the quote unquote abuser. And to one of the points earlier, it's clear in what Google did, based on prima facie what was said, that they introduced a mechanism to go around one of Apple's protections. Okay, so there were no damages found in this case or whatever, but Kenny, when you say, you said there's a floodgates risk, I actually made a note to myself, the Supreme Court has opened the floodgates, but the tide is fortunately out at the moment. My question to both of you is, do you think that there is sufficient jeopardy arising from the consequences of the Supreme Court's decision to change some of the behavior of the corporate principals, some of the corporate principals' behavior?
Leah, do you want to, I'm happy to answer, but I've taken the first couple number of questions. If you want to go first.
I don't know. But I mean, from what I've been commenting in the chat, I'm not sure if you're aware, Kenny, but I've been typing in the chat. But I mean, I think that the risk of a class action is really something that the leaders of the big tech companies and businesses generally is front of mind and is keeping them up at night. And so I you know, I imagine they'll be relieved at the Supreme Court decision, but at the same time, I do think that there's a deterrent effect in what was said, in that, you know, these are possible. You just got to bring the claim in the right way. You've got to sort of think creatively about how to bring the claim. But there's more guidance. I mean, now from a top court condoning the use of these mechanisms. The Supreme Court expressly didn't pass any kind of comment on what Justice Warby had said about this being officious litigation and kind of a pointless waste of the court's resources. So I mean, it's you know, they didn't approve that. They didn't really say anything about it. And had they agreed with it, they would have approved it, and they certainly wouldn't have set out kind of the blueprint that they have for how to use these mechanisms. One of the things that you may find quite interesting, and this comes from a comment, and I can't remember who said it, but basically it's a comment that says, you know, one person's damages may be £3, but when you aggregate them all together, that's really where change can occur. And
that was my comment, Leah.
That was
exactly.
your comment.
Yeah,
okay, great.
Exactly right. Yeah.
Great. So I mean, I wanted to kind of respond to that in saying that the government, since the Lloyd and Google decision, so Kenny mentioned this consultation that they'd run. I've just pulled it up on screen, and I'll share the link. But basically, it was a consultation on whether to introduce a mechanism like the competition mechanism, where you can have aggregate damages and you can have sort of a less narrow same interest test applying to allow these actions to go forward. And they said, well, because of the Court of Appeal decision in Lloyd and Google, you've got that mechanism, you know. And since then, I actually haven't seen a direct quote. I've only seen quotes in the media and in the legal press saying the government has come out after the Supreme Court decision and said, we're not going to be re-examining that issue. And maybe that is really one of the solutions that individuals should be advocating for, is government reopen that decision not to introduce such a mechanism, because the mechanism can be really powerful. It can be used sort of for public interest reasons. And actually, so I'm from Australia, and many of the class actions there were for public interest purposes, like, for example, by asylum seekers and those in Australia's ridiculous immigration detention centre. So it's, you know, maybe that is kind of a solution that, from the comments I'm hearing, is one to be grasped at and one to be argued for, because it does have great potential to change behaviour where there is a greater risk of that kind of action.
I would just make one very brief comment, which was there was a comment towards the end of the question, and I think was raised elsewhere, about kind of changing corporate behaviour, which is, and there's overlapping policy questions here. You know, we talked about the compensatory purpose of civil litigation, which can of itself also encourage change of corporate behaviour if corporates. I mean, I don't think there's that many companies. I'm not saying it never happens, and improper conduct is indefensible and shouldn't be defended. But I'm not sure that there are that many instances where they draw up a spreadsheet and you know, weigh up the cost of good versus cost of bad conduct. It has happened, and I'm sure will continue to happen, but I think it's relatively rare. But actually, in my experience, and what we see more and more of, is other, not just damages ground basis, which really encourage better corporate behaviour. You know, social media campaigns, ESG considerations, drivers by, you know, employees who are younger than myself who wish to work for companies that do the right thing. there are a range of developing factors weighing on corporates that have greater and better encouragement on them to do the right thing and to more pertinently avoid doing the wrong thing, which I think probably have broader impact, really, more generally. So class action risk does have a role, but it's certainly not the only part of this.
That's great feedback. Thank you. I mean, my view on this is that I've worked for corporates for most of my adult life. I promise you, there are people with spreadsheets that make calculations like these. I won't name names, but one in particular told me that the advertisers have so much information that they spook people if they would reveal it. So I've worked for a company that has taken steps to obfuscate how much information they have, so that you think you've happened upon an advert rather than it being the first thing you see, because you would be, how did they know that, right? And you anecdotally see this in consumer conversations now, where people say, have you noticed how you mention something and it appears in an advert, right? I'm sure that isn't the case. I think what's more likely is that the things that they mention are the things that they're searching for anyway, and so the connection is there. But it may be, and I'm absolutely sure the Supreme Court had this in mind, that they're opening up a mechanism to give an indication to corporates that behavior perhaps needs to change. But again, let me close by saying I really, really thoroughly enjoyed this presentation, so thank you.
Great, thank you.
Can I just pick up on a question from Peter? Because it's actually a really good question as well. So he said, I think Google made money from the breach from advertising revenues, so they could pay damages based on account of profits as well as MPI distress, etc. And something we haven't really touched on is Lloyd's claim was funded by a commercial litigation funder. And I mean, one of the reasons why, because when I first read the decision, and at the High Court level, and I was thinking, why didn't they plead MPI? Why didn't they claim damages for distress? And the answer to that lies in what is commercial for a litigation funder, and also what fits within the same interest test. So as soon as you get into trying to prove that each individual class member suffered distress, immediately you're into territory where you're having to prove loss on an individual basis, and the court then can say, or the defendant can then persuade the court much more easily that it's not suitable to go ahead on a class basis where everyone is bound by the judgment unless they opt out. And so it's a really good point. If they made money from the breach, well, they should disgorge those profits. But I think that the question for a claimant is, how do you persuade your litigation funder to run certain arguments that may be kind of points that need to be tested, but they may lead to your claim being more high risk and therefore less likely to attract investment from a litigation funder. So the dynamic between sort of what actions are run as well and sort of what litigation funders are willing to fund is quite interesting, I think, as well. Just wanted to kind of respond to that.
Thank you, Leah. And also similar to Peter's question was also Mr. Harmer's question. He also mentioned that negative publicity may have led to advertising revenues on behalf of the company. I don't know if you or Kenny wish to have a last statement on this, and I believe that after your last statement will be the time to wrap up.
I responded to that point taken, Jeremy, because he was responding to something I said above, actually, which was, even if the claim is not successful in the end, the negative publicity that Google attracts from it is a good deterrent. And actually, like a brief sentence on where I'm coming from with that is I ran two actions in Australia for a woman who's blind and who established a advocacy organization for digital accessibility, so making obligations on businesses to make screen readers, make websites accessible to screen readers and that kind of thing. And although that case settled, though both cases settled, they never went to court, the outcome was so powerful, and the change and the programs that the organizations have since implemented is astounding. And so I was thinking, well, you know, the publicity they get and the risk that they look at, oh no, if we don't do this, we're going to end up in the paper again, or the Daily Mail tests, right? That's where I was coming from with that, but absolutely point taken. The more airtime Google gets, the more ad revenue they may get. So yeah, point taken, Jeremy. I don't know if Kenny has anything to add. That was just a kind of, it was an aside conversation in amongst the questions.
Yeah, I think that's the no publicity, no such thing as that, right, isn't it? Yeah, no, my closing observation is really just to go back to the slides at the start of the presentation, that at a macro level and outside of data protection as well, we are seeing more and more collective proceedings coming to Europe. I'm not sure we'll ever get to the stage it is in the US. But this is happening. You know, Lloyd and Google stopped the floodgates for data protection class actions, but it doesn't stop, you know, the subcategories that were already viable, and it's broadened the categories that will be available outside of data protection as well. So it is a kind of a ever moving forward, increasing availability of these mechanisms. And you know, we'll just, you know, and that's not just in the UK, it's elsewhere in Europe as well. So yeah, those are my closing comments, I guess.
Okay, thanks, Kenny. Thanks, Leah. I'm sure we could speak for hours on this. Yeah, I do really appreciate your time, and I'm sure that the BCS members do appreciate your time. I know obviously how busy you are, so really appreciate you taking the time out this evening. We've done a number of these events, and I can say in terms of the interaction engagement, this is one of the most popular, if not the most popular. So well done, guys. So that's great news. I think the downside for us is, you know, following this up. So you've set us a good challenge, so thank you very much. And to all the people who attended, thank you for attending and showing your support during the year. We hope you have a very festive season and have a safe one. And we look forward to sort of continuing this dialogue next year. And if you've got any ideas for any events or any speakers or topics you want us to cover, feel free to email myself or any member of the committee, and we will endeavour to find those speakers and so forth. So thanks again, and thank you, Kenny, thank you, Leah, and yeah, everybody have a good evening and keep safe. Thank you. Good night.
Thanks, everyone.
Thank you.